Welcome to the Dealmaking with Laura DiFrancesco podcast. I'm Laura DiFrancesco, your host. We're talking all about mergers and acquisitions, buying and selling small businesses, as well as corporate law. We are taking our experience closing over $10 billion of transactions since founding Dean Street Law 5 years ago, and my experience being an M&A and corporate attorney for over a decade and making it accessible to you as an entrepreneur. I hope that this helps you in navigating the complex world of mergers and acquisitions. And also, we're always happy to be a resource for you here at Dean Street Law. You can always apply to work with us through our complimentary consultations linked in our show notes. And a huge shout out and thank you to everyone who's subscribed and left us a 5-star review. If you haven't yet, be sure to subscribe and also leave us a 5-star review. It's one of the best ways to support us as a small business. And also be sure to share with your friends and colleagues on social media, through text, email, or however is easiest. It means the world to us that you're supporting our content and helps us make more to support you in your journey. Welcome back to today's episode of the Dealmaking with Laura DiFrancesco podcast. I am so excited to chat today through post-closing legal processes because so many people are so focused on buying a business, getting to closing, that oftentimes the thought process of what happens after closing, particularly from a legal support standpoint, can be left to the wayside until you're in the thick of it and then you have a closing and you're like, okay, what happens next? So today we're going to be talking about what happens next. I am your host, Laura DiFrancesco, founder of Dean Street Law, our mergers and acquisitions boutique law firm, and I'm also the author of Entrepreneurship Through Acquisition, a legal guide to buying a small business. If you'd like a complimentary copy of the first chapter and the ability to learn more about the book, where we cover all of the different components of buying a small business from a legal standpoint, including due diligence, LOIs, closing preparation, documentation, as well as post-closing support. It is all there available for you in the show notes. And it would mean the world to us if you leave a 5-star review, and you can send the 5-star review copy to etareview@lauradifrancesco.co to receive a pre-LOI due diligence request list on the house. So let's get started talking about post-closing legal support. And this is the perfect timing right now because we just had a big closing for a deal that's been going on for a year. So talk about negotiations, getting to closing, the anticipation. But before the deal even closes, we are already working on your post-closing legal support, because post-closing legal support starts the moment closing happens, and you have to be prepared, especially from our legal standpoint, to make sure that you're successful in the post-closing phase. So there are a lot of different processes within this, both from a business, logistics, and legal standpoint. And we like to have conversations with our clients throughout the process to talk about each of those. So today we're going to be talking about transition planning, the legal obligations after closing, operational legal support, dispute resolution, and risk mitigation. So while post-closing is something that you don't necessarily start to think about from an operation perspective until perhaps later on in the deal, getting towards closing in the next, the 2 weeks before closing, you might be thinking about what do we need to do post-closing, but your attorney should be actually thinking about that in the very beginning of deal structure, because transitioning a business and the process of transitioning a business is deeply nuanced, and from an operational perspective and a legal perspective can have a lot of different requirements and implications depending on the target business, what assets are being transferred, whether it's an asset purchase or a stock purchase. So we, as your attorneys, are thinking about your post-closing transition the entire time. And so that is going to make our way into conversations about structure. If there is a lot of direct payments from big customers to a specific bank account, then we want to talk about an asset purchase agreement, including the transition of bank accounts. In some asset purchases, that may not be a priority, because if they're just receiving checks and they can then determine how it's deposited, then it's not as much of a consideration and need for consistency through that transition. A lot of transition planning is, how can I make the transition legally effective and also something that is minimally disruptive to the customers, to the business, to the employees, so that the business can continue from a cash flow perspective as well as operational perspective, moving forward through the transition without a blip, without even any snag on operations. So we're thinking about it from structure, and that includes, what are the assets that need to be transferred? If there's vehicle titles and it's an asset purchase, that's a much different process. If there's real estate and it's an asset purchase, again, a much different process than, say, if you have a stock purchase and the real estate is owned by the business, which isn't very common, but just for example. Even in the case where you have a stock purchase, like we just had a closing for a stock purchase, but it was a busing company. And so there were over 70 vehicle titles that need to be transferred, not because the name of the owner was being transferred, but because we had to satisfy all of the existing debt. And then we had to record the new secured parties for the new lenders for all of those vehicle transfers and vehicle titles and changes. So there can be a lot of logistical components, particularly dependent on the type of business, the assets that it has, whether it's a stock purchase or an asset purchase. So structure will be highly influenced by post-closing integration. And then in addition to that, your closing conditions are also going to be heavily driven by post-closing transition and logistics of closing. So for instance, on an asset purchase, I'm thinking of keys and access. And I also like to include simple things such as the seller providing a list of all of the accounts payables or payables that are on auto payment and which cards that they're associated with or how different bank accounts are used. And yes, that is a part of due diligence, but having it as a closing condition and element that needs to be provided, and closing deliverable, I should say, rather than closing condition, then it's something that becomes even more important to the parties to iron out. Of course, working capital is something that is a big component working up to closing, and there's a lot of nuances around deliverables of, well, I guess depending on really how you structure working capital, whether there is a working capital adjustment, how that working capital adjustment is formulated as a pre-closing condition, closing element, and post-closing element. So that can be really nuanced and different depending on your sources of funding, as well as overall the impact of working capital on the business and whether the parties have negotiated to include working capital or not. So it's definitely going to be something that you're thinking about. And then you're thinking about access, keys, bank accounts, all of the things that you need to be able to logistically take ownership of the business. And that may also include having conversations about, okay, once we close, are we going to have a conversation with employees pre-closing, which is not typical, the day of closing, which is less typical, or the day after closing, which is most typical. So having those conversations about control, transfer of management, all of that, a lot of the time in the LOI and the ancillary transaction documents, there's going to be conversations with the seller about their role post-closing, but sometimes part of the conversation that buyers need to remember to include in that conversation is how they'll be stepping into leadership as well. Like, are they going to have a meeting with employees the day after closing, which can be hard if you have a closing date that's moving. That's always a challenge. It might need to be something less formal, like coming into the office and just having something ad hoc. But obviously, your plan as the operator is something that you should focus on and be mindful of. And I think that we have actually at least one post-closing operational conversation on the podcast already. We'll link it in the show notes, where we've talked about having a 90-day plan and how important it is to really learn and observe before making drastic changes unless there's an immediate need, like the business is going into bankruptcy. Otherwise, you really want to hold tight, listen, observe, learn before making big changes, particularly in technology or operations or the way things are done for delivering customer services, because you have to really understand and be able, and I think it's important to talk to the people, like maybe they've explored the same technology and decided that wasn't a good option because of this issue. And without having operated the business yet, it will be hard for you to know those specific elements. So having that time where you really take an opportunity to not necessarily take a back seat because you are the owner operator, you're in charge of making sure that this succeeds, but taking ego out of it, taking the idea that you know best out of it, and coming to the business with saying, I have these ideas of where we can go, but let me listen and learn and test those ideas and test them every day before you start implementing them, because ideas are sometimes expensive in terms of time and implementation costs. And you want to make sure the ideas that you implement will be able to be adopted and taken on by all of the team members as well. Because if you pay for a technology, but then no one uses it, it's a bad ROI, and we don't want that for you. When it comes to navigating corporate law, entrepreneurship, and managing small businesses, experience matters. Dean Street Law is a boutique corporate firm specializing in mergers and acquisitions and additional focus in real estate, commercial transactions, finance, and corporate governance. With over $10 billion in deals closed, Dean Street Law has extensive experience representing hundreds of clients in thousands of transactions, from small businesses to Fortune 500 companies. Whether you need startup guidance or advice on closing multi-million or multi-billion dollar deals, we're your trusted partner every step of the way. Visit deanstreetlaw.com in the show notes to schedule a complimentary consultation. So transitioning planning, you're going to have that 90-day transition plan. You're probably going to have overall a more immediate transition plan as well, of thinking, how do you want to have those conversations with employees? Do you want to have conversations with customers? Do you not want to have conversations with customers? That's going to depend on how involved the seller is on a day-to-day basis with customers. If the customers don't know who the seller is, it would likely cause more trouble than not to have a conversation with sellers about transition. Now, if the customers are with the seller and there's customer concentration, then you may consider talking to a handful of top customers. But you want to, it depends on strategy, but the general strategy is to make things as minimally disruptive as possible while maintaining trust and reliance, customers' trust and reliance on the business. The next item is deciding how involved the seller should be. Now, we talked about that already, generally being involved in the LOI and also the ancillary transaction documents. The knowledge transfer is super important, but most of the time the seller is going to be winding down their involvement. In a few cases, non-SBA deals typically, where you're going to have the seller involved more long-term, there is going to be perhaps a different strategy on keeping the seller in place and keeping them managing the business, but growing the business in a different way. And we have plenty of deals that we work on for that. But most of the time, especially in ETA and lower middle market deals, there is a plan to transition management of the business. What we like to do when we're structuring documents for that is to have it be at the discretion of the parties and up to a certain maximum amount of time, but not a minimum amount of time, because it depends on whether there is a challenge from the buyer's perspective to take over the business and take over the influence and management of the business, because sometimes when the seller is still involved to a really high degree, the employees may continue deferring to the seller for the management of the business when that should be transitioned to the buyer of the business, unless there's an agreement otherwise that the seller is staying on to manage certain parts or something like that. So we want to have the process be as productive for both parties as possible, Oftentimes, but not all, the seller is looking to transition and wind down quickly and trying to retire or something like that, but not all the time. And so there may also be a desire for the seller to be more checked out. And so we want to have plans for what is the commitment of time? Is it in person or not during business hours, which can be really important, just to make sure that there's clear expectations from the parties and that those are set forth in the ancillary transaction documents, as well as developed in the buyer's transition plan. So those documents, ancillary transaction documents, like a consulting agreement with the seller or an employment agreement with the seller, as well as the overall provisions within the closing deliverables or the closing conditions in the purchase agreement, and the structure overall will not only take an implementation plan, but effectuate an implementation plan. So there is a lot of collaboration between operations, you on the buyer's side coming up with a transition plan from a business perspective, and your attorney who's going to be able to legally implement that and make sure that incentives are aligned, the documentation has what it needs in it to create consistency through the transition. That's really important for maintaining cash flow and the success of your business post-closing. Now let's talk about the legal obligations after closing. So there will be a number of elements that are not completed at closing. And there may be sometimes even things that you wish that were completed by closing, but are they need tos, or are they must-haves, or are they things that we would really prefer to happen pre-closing and we will all work hard to do? But if it's not completed pre-closing, then it will happen post-closing. So the first and easiest things are the ongoing obligations under the purchase agreement and ancillary transaction documents. So you're going to have ongoing deliverables. So let's say that there's your indemnification lasts for 18 months post-closing for non-fundamental reps and warranties. So then we're tracking that date. Or with working capital, you may have a provision in there where estimated working capital statements are delivered pre-closing, maybe within a couple days of closing. You close on what's estimated, or you get re-updated estimates on the day of closing, and then you have a certain period of time to look back and audit those once the buyer is in the seat at the business and able to have a better understanding of those numbers and work with their accountant to audit those. And then there's a post-closing adjustment of working capital if necessary, if there was any issues, not any issues, but any changes from the estimated working capital to the final closing working capital, because it is expected that there are going to be differences. It's very hard to fully 100% correctly estimate the payables and receivables in a business. It's some of these things are just, you don't know until after you close what the final numbers and books will be, and that's normal and that's okay. That's why we have post-closing processes to true them up so that it's accurate. If it's an asset purchase, one of the other post-closing deliverables will be to have the seller change the name of the business, because the buyer will typically adopt the name of the business either as a DBA, or they'll have a entity that will be the same name as that seller's entity. And so that may be by having the core name the same, and then it just be a different ending with like XYZ Corporation or XYZ LLC. Another way that it might be done is you can have the same name if it's created in different secretaries of state. And oftentimes the buyer would need permission for that name to be adopted, but that's part of our pre-closing work that we do. And then post-closing, the seller would need to change the name so that there aren't two businesses operating under that name for legal risk mitigation. And so that's one example of a post-closing. Other examples are, it's going to be a closing condition that all of the debts of the business, not in all deals, but in most deals, it's going to be a pre-closing condition or a closing condition that the debts of the business are paid off, or they're paid off in connection with closing. And so while you're going to get payoff letters pre-closing, and some small debts may be paid off pre-closing, most of the time you're going to have evidence of that debt being paid off post-closing. So you'll have lien satisfactions, or if there's a mortgage satisfaction, something like that. If you have financing statements evidencing liens on the assets of the business from the old lenders, if you have those from the old lenders, then you might have UCC3 termination statements to terminate those UCC1 financing statements. So those are just a couple examples of how you're going to have those post-closing. Now let's talk about third-party consents. In due diligence, you're going to be reviewing the requirements for third-party consents from the buyer's perspective, and then you're also going to have the seller represent and warrant as to what third-party consents or notices are required for the deal. So you're going to have the buyer doing their own due diligence. You should be doing that with your attorney, and then the seller is also going to be representing and warranting as to what closing consents and notices are required. With that said, there are certain consents that are going to matter more than others. And so there may be consents required for the transfer of a SaaS company, like your Microsoft click and accept. And if you look at the contract, it may require consent to transfer that. Does that mean that you're going to stop the deal because you didn't get Microsoft's consent? No, you're probably both going to agree not to get that consent. And I'm not saying that that's what the contract says, but just by example, you don't want to hold up the deal for certain third-party consents. If there's a printer rental agreement or something, and the printer rental agreement says that you need consent to transfer, you might just risk it and be like, if this is an issue, I'll just get a new printer. There are other consents that are really important, such as the top customers and whatnot, and the parties may not want to risk that. Landlord consents are also typical. That said, it can sometimes be either difficult to get the consent, or the requirement may be for notice post-closing. So anything that's notice post-closing, you would put into your post-closing timeline of what needs to be done. And then anything that's consent pre-closing, you would work to get. But sometimes there's a very, very expensive implication if closing is delayed. And particularly in bigger deals, they may waive certain consent requirements and provide in the documents that the parties will work in good faith to obtain the consent post-closing, because it may not be a consent that is either something that they think will be an issue, like perhaps they think the landlord will sign it and have no problem with it, and they will in good faith work towards it. Be very careful with that, especially with landlord consents, because right now there's a big trend with the price of interest rates going up and cost of everything going up. When you have short-term prices and costs going up, but you have a long-term obligation such as a lease, landlords may use opportunities such as requirements for consent or assignments or something like that as an opportunity to renegotiate the lease or require exorbitant fees for transfer fees. And that may be something that you want to be very careful with and not leave that as something that you're hoping is something simple, only to find out that it is not. So you have to be very careful with what the parties decide to not have as a pre-closing consent that should be a pre-closing consent. But ultimately, business is all risk mitigation, risk decision making. Anything can happen at any time in a business, and your lawyer's responsibility is not to tell you you can't close the deal until you get every single consent, but rather say, these are the consents that are required under contract law. Here is the potential risk if there's an issue with obtaining this consent. And you then, as the buyer or seller, may make the decision as to whether you would like to proceed with closing despite that requirement. And ultimately, you need to make a decision as to whether the risk is worth it. So there's a lot of nuances in that. Overall, those are just a couple examples, but our process is, as soon as we're preparing for closing, we're making a post-closing timeline of all of the elements within the transactional documents that will occur post-closing, and all of the timelines, as well as other things that we have decided are post-closing deliverables. And that'll include your escrows, employment agreements, indemnities, post-closing obligations, that post-closing checklist. And that's going to be part of your timeline. Now, post-closing legal support is going to be very different from attorney to attorney, what that looks like. We prepare a closing binder, send it to our clients so they have a copy of it. That's all of the signed documents and all of the closing deliverables in a binder that is sent to the client so they have a copy of it. We also send them the post-closing timeline, which I know that most law firms don't do because when working in big law, I never saw a copy of something like that, but I always thought it would be super helpful. So that's something that we implemented at Dean Street Law. And then as to post-closing support, we at Dean Street Law also provide assistance with contracts. So let's say in due diligence, you realize that you're missing key contracts or contracts need to be revised or redone. That may be done in a strategic way, such as after closing, you may have a contract that's not going to renew for a year, but you want to start working on what that would be before, because you don't want to wait until the contract doesn't renew or auto renews before you start having contract negotiations. And if there's anything else in due diligence that is a post-closing item to address, we'll note that in our due diligence report and conversations. And that may be employment contracts. You may want to do full compliance vetting. So particularly on really high compliance industries and companies, it's not always worthwhile to do a full compliance due diligence because you're going to be having the seller attesting to compliance and also showing you in due diligence any compliance notifications or issues that they've received in the past. So because of indemnifications, as long as you have a good indemnification and good representations and warranties and good due diligence, you should feel satisfied with compliance initially going into the deal. But especially if you're looking to expand or you're wanting to improve the operations post-closing, you might do independent engagement of a consultant with compliance background with that specific industry to go over full compliance. And that is oftentimes not just compliance, but also processes. Like, how could we be doing this better so that it's not only compliant, but also saves us money or has a better return on investment and everything. So compliance consultants can have a multitude of things that they assist with. And new owners, once you get into the business, I would start thinking of legal as a constant budget item. Oftentimes people think of legal as when we need it, we'll take care of it. And unfortunately, that can create situations where, because you may not be familiar with when you need it, or the daily requirement may not be as much, but then if there is an issue, it's a $50,000, $100,000 or more issue. It would have been better to spend a couple grand on good contracts than to have a lawsuit that's going to cost you at least $100,000 or even just $50,000 making it go away because the contracts weren't clear or something like that. So marketing has its own dedicated line item in your budget. If I were you, I would have legal have its own designated line item in your budget and plan for regular check-ins with your attorney, especially if you have investors, if you have other people owning the business, you are going to need a certain amount of documentation on an annual basis around decision making. And we can guide you through that process so that you can do most of it yourself. But remember, there are annual filings when you own a business, both with the Secretary of State and of course with the IRS. So you're going to want to be on top of those from a business operations perspective. And then overall, you kind of want to have your contracts audited. It's going to depend on the value of those contracts and how much they change based on the operations of the business. But you want contracts to keep up with your business. So I would have them audited every other year, every 3 years, maybe do an initial audit based on your due diligence and ask, what should we be revising if you have independent contractors and don't have independent contractor agreements. I would highly recommend them. If you have employees, they're key employees, and you don't have employment agreements, I would recommend them. We do have conversations about those, particularly in lower middle market businesses where maybe people are used to having offer letters, which you can do when accompanied by good employment policies and whatnot. So there's a lot that you can do to continuously invest in the legal aspects of your business. As an attorney, as someone who has 5 businesses of my own, I do have legal that I do for every single business every year. A new contract that we need a template for, or updating contracts based on new operations or new relationships that we have from a customer or vendor perspective. So you want to make that a consistent part. Thinking about buying a business? Unlock the secrets of successful acquisitions with Acquisition Insights, your legal roadmap for success. With over 81 modules of video lectures, written materials, guides, and checklists, we provide in-depth guidance to navigate every step of the process. From initial interest to closing the deal, get the expertise you need to make informed decisions. You can also access our battle-tested templates in the Acquisition Insights course and templates bundle, including our template LOIs, letters of intent, pre- and post-LOI due diligence request list, material deal terms lists, and more. Visit lauradifrancesco.co/the-shop today and take the first step towards buying your dream business. All the links are in the show notes. Part of post-closing is also dispute resolution and risk mitigation. So we have the provisions for indemnity in there if you need them. The goal is to have good due diligence and good operations so that you don't need them, but if you do, they are your backup. So what happens if something goes wrong? Immediately have a conversation with your attorney and how you should address it. You really want to have things be a conversation and work proactively to resolve things before needing to get lawyers involved, but that doesn't necessarily mean that your lawyer is not involved. Just because they're not sending a letter doesn't mean that it's not helpful to have a conversation about what the requirements are and what some potential solutions are before escalating it to send a letter of default or something like that. Because once you get lawyers involved, it can very quickly and easily get egos involved, and then it becomes harder to find a resolution. And finding a resolution is oftentimes the least expensive way to solve a problem. Does not mean it is always the right way to negotiate a solution. Sometimes litigation is the best way to address an issue, but oftentimes it's a very expensive way, and most of the time, the very significant amount of time, it is not the best way to resolve an issue. And then how to structure support to handle anything that comes up quickly. Having a relationship with your attorney does not mean that you always have to have an engagement. It depends on your attorney and what they're going to bill you for, but most of the time in big law, and also in my practice as well, it's not going to cost someone to have a conversation around, hey, we've got this going on. Unless you have like a retainer or something like that, most of the time that's basically a consultation call. And then your attorney is going to say, okay, here's what we can do, provide you a quote, and then we're going to move forward with an engagement. So I wouldn't shy away from attorney involvement, and generally it will save you considerably more over time. And then protections being built into the agreement. So I do recommend having not only good representations and warranties and covenants and indemnification, but also provisions that can actually work for you quickly. So set off provisions and clawback provisions in seller notes are an immediate way that there can be a resolution of an issue without someone having to pay someone right now. Now, that doesn't necessarily mean that that's always going to be the best option, because if you know that there's a liability, if you know that there's a lawsuit or something like that, you may want to have an escrow of certain funds built into your structure to address that known liability, because that will become a cash flow disruption, and you want to be very careful in the first several years of operating your business with a very keen eye for cash flow disruptions, because cash is queen in doing business, and you want to make sure that these potential hiccups post-closing don't become a big issue. Those are also going to go deeper into your indemnification provisions around baskets, which is basically your deductible that must be hit before indemnification claims may be made. And indemnification, by the way, is one party's obligation to legally make the other party whole if there's a claim by a third party or that party themselves. And so there may be baskets, which are your deductibles essentially, and they may either start at the dollar after the deductible or start at $1 once that deductible has been met. And then the other things are caps as well as timelines. And something else to think about though is what other things from a logistical standpoint could be helpful. So from a seller's perspective, that may be on the seller note. If it's a large enough seller note that it warrants it, and this is not all of them, it may be certain backups of protections like personal guarantees or security agreements, UCC1 financing statements, liens, stock powers, pledges of stock or pledges of ownership interest. So there's protections that you can have as your protections for if something goes wrong, and that's all in structure that your attorney is going to be working on the entire time. And then in addition, we also want to have dispute resolution provisions because it's not beneficial for anyone if the first thing that people do is file a lawsuit because there's an issue. You should have a certain period for negotiation, an escalation. If it's, something that you want to go to mediation, mediation is where the parties basically work through their issues with the guidance of a third party that doesn't make a decision. And the mediator says, so-and-so said this. This is maybe the benefits of their arguments, or this is maybe something that would be beneficial to agree upon. It kind of like works the parties together to come to a resolution. And arbitration is something where a third party will decide and become a trier of fact to make a decision that may be non-binding or binding. And there's a kind of like more, not a litigation setting, but a more tribunal setting where you have parties representing each other and making cases instead of having a conversation. And then the third tier is going to be litigation. So you may want to have dispute resolution as well as where that dispute will be resolved. What's the venue, which is the location where a dispute may be made? What's the governing law, the law that will apply in the event of a dispute? Those things may be things that you glance over and not care about, but they actually become very, very impactful and important post-closing. So those are just a few things to think about when thinking about post-closing. If you have an opportunity, I would love to know what is a topic that you'd like to hear about on Dealmaking with Laura DiFrancesco on our next episode. We have some great ones coming up. We're going to be talking about timeline of buying a business, acquiring a healthcare business, communications with your attorney, what's it like working with Dean Street Law, and more. So I'd love to hear what you'd like to hear about. And if you haven't yet, please be sure to leave us a 5-star review, share with your friends, leave us a comment on social media, and also check out my new book, Entrepreneurship Through Acquisition, a legal guide to buying a small business. Cheers and happy deal making. Thank you so much for joining us on this episode of the Dealmaking with Laura DiFrancesco podcast. I hope you found today's discussion insightful and that it brought you one step closer to mastering the art of mergers and acquisitions. If you enjoyed this episode, please be sure to follow and subscribe to Dealmaking with Laura DiFrancesco on your favorite podcast platform so you never miss an episode. And if you found value in our discussion, please leave a 5-star review. It would mean the world to us. And share this podcast with your network, friends, and colleagues. For more in-depth resources, be sure to visit our website, deanstreetlaw.com, where you can find articles, guides, and more information on our services. Don't forget to follow us on social media for the latest episodes, updates, tips, and exclusive content. You can find us on LinkedIn, Search Funder, at LMDFrancesco on X, and at Dean Street Law on Instagram. Join us on our next episode where we'll explore more deal-making insights. Cheers and happy deal-making.